Good morning to all the delegates attending this virtual conference online organized by Quaynote. Thank you very much indeed to all the organizers for this kind invitation. Very exciting to be with you again. And the plan is for me to share some thoughts with you relating to the arrest of yachts and what happens after we arrest yachts. Now, the first thing I'm going to ask you is to bear with me because our IT manager is putting my IT knowledge to the test here, because I'm going to shift from having a full screen to sharing my PowerPoint presentation with you. So I have now got to don my glasses and hopefully I will be pressing the right buttons and everything will work according to plan. So here we go. I'm going to share my screen now. And there we go. Excellent. So all things being equal, hopefully you should be seeing my PowerPoint presentation here with me on your top right-hand corner. So what I'm going to be talking to you about today is what happens when you arrest a vessel. And right, so that's not working. Hopefully this will work. There we go. So off we go. What we're talking about here normally is the excitement of buying a yacht. Normally, all of us as service providers are with clients who very frequently explore the Monaco Boat Show, and we are thrown in the middle of all the glamour, of all the excitement, the enthusiasm, and the happiness of owning a yacht. Very, very special times for the owners who obviously go around the boat shows, who go on various boats, who conduct numerous street trials with a view to finding that ideal yacht that's going to take them away from the run-of-the-mill day-to-day to days, weeks, months, and years of enjoyment. And these are the scenes which so many of us are so very frequently, so very often see with our own eyes, because this is the scene that accompanies this sector. Typical, what I call happy scenes of lovely yachts with our clients who go through the shows, figuring out which one they are going to purchase. Of course, these are yachts which, these are photographs which I've taken myself actually, and naturally I was drawn to those yachts flying the Malta flag. Quite apart from the real reasons and the important reasons why prospective purchasers opt for flying the Malta flag, Alison and I, who you all know, always think that our flag just looks absolutely marvellous on the back of these wonderful super yachts. So here we go, this typical Monaco scene with all the fun that accompanies it. However, that's what happens when the going is good. So what happens when the going turns bad? And unfortunately, a number of us who do attend boat shows, who are involved in sales, who are involved in drawing up contracts, very frequently do not really appreciate or possibly come into contact with scenarios when things don't go according to plan and when things start to go bad. Of course, we've had global recessions such as the one in 2008, which affected people, which affected people's spending power, which affected the actual financial situation of clients. We have situations where there is a decline in the financial status of those individuals due to personal reasons. We have extra supervening causes such as COVID-19. All of these can have a very, very drastic effect. Now, very often we tend to associate these affairs with merchant shipping. But unfortunately, this sort of situation does not only affect persons involved in commercial merchant shipping, but also affects the bottom line of a number of persons who would have previously spent vast amounts of money on their super yachts, and things just don't turn out the way they would want them to ideally. So Any of the reasons which I've just described can, and several others of course, can and may lead to the following. You can have a situation where an owner is unable to pay his financiers. We can have a situation where the owner is unable to pay for supplies and provisions. We can have a situation where an owner is unable to pay for repairs, for bunkers, crew, managers, unable to keep the yacht. All of these situations can and do, most unfortunately, and I must admit we have seen these happen, we have seen this situation on a number of occasions, regrettably, can possibly lead to bankruptcy. So what are the options? What are the options available to the bank whose clients have stopped paying their mortgages? What are the options for the owner when he is unable to pay his creditors? So the first option, of course, is to renegotiate some form of refinance package. Sometimes that works, sometimes that doesn't. If he's unable to obtain refinancing, very frequently, the only thing left to do would be to sell the yacht so that the owner can repay his creditors. But even there, this is a very sticky, this is a very difficult situation because, unfortunately, when an owner is unable to pay a creditor, it is frequently associated with the owner being unable to pay a number of other creditors. So, you know, there is when an owner has to resort to selling his yacht privately, there is an enormous amount of trust here with creditors. And very frequently, the concern is that creditor A does not have the visibility on creditor B, C, D, E. So this can lead to a very uncertain situation, which means that when creditors therefore seek legal advice, that legal advice inevitably is, look, don't take any chances, just arrest the yacht in a jurisdiction which is reliable, which is straightforward, which is transparent, which is uncomplicated, and which is fair for all. And by fair for all, we mean fair for the creditor, but also fair for the owner. Because what we mustn't lose sight of is the fact that if this poor owner is in an unenviable situation of being unable to pay for his debt, then the last thing he wants to do is to be taken to the cleaners, have his yacht sold at an undervalue. So what we really need to do here is we need to protect the position of creditors who need to take what is due to them, but we also need to protect the position of the owner in order to try to ensure that we get the best possible price for the yacht. So after he pays off all his debt, there's something left over for the creditor. So this is the advice we always give in these very, very challenging situations. They're not happy situations, and there's a tremendous amount of responsibility on the part of the legal advisor to make sure that he is advising in a correct and objective manner. And so this is why we need to have a reliable jurisdiction where we can ascertain that we will have all those things which I have just outlined there. Now, sometimes we have a different type of situation. So let's imagine your creditor, your yacht owner, hasn't paid his debt. Sometimes it isn't a matter of bankruptcy. Sometimes the owner does not pay, not because he is bankrupt, but because he is playing hard to get with a particular creditor, because he wants the creditor to give him a better price, because he wants to negotiate. Now, very frequently, in that sort of situation, if you arrest a yacht in that situation, that arrest very frequently leads to the required nudging which that owner needs in order to get him to settle. So you arrest the yacht, the owner becomes frightfully offended because you've dared arrest the yacht, and within 24 hours, the check is in the post. So that's a good thing, because if that is what it takes in order to get an owner to pay his debt, so be it. That is in the case when the owner is not bankrupt, he's just playing hard to get. So you arrest the yacht, and in our experience, within a very short period of time, the settlement monies will be paid up. If, on the other hand, your owner is bankrupt, so, you know, and this is not a question of reaching a settlement because he's got no money to pay. Well, in that case, there's only one way to go. We need to sell that yacht to recoup as much as possible to pay off the creditors. And this is where we need to be guided very, very well. And this is where one needs to consider the choice between a private sale so the owner sells the vessel privately in order to pay off the debt, or a judicial sale. And the judicial sale is a sale which is regulated by a court of law. And what exactly is the difference? And this is very important. Now, in a private sale, of course, the number one advantage is that you go out to the market and you negotiate the best possible price. You go out there, you find a buyer, you like the price, and you sell. Now, unfortunately, however, that doesn't come without its disadvantages. And the main disadvantage is that when you sell a vessel privately, it is not sold free and unencumbered. So if I have financial difficulties and I decide to sell my yacht, and I find Mr. X who's prepared to buy it, and I sell that yacht, very often that yacht is sold with the debt which is privileged, which follows the ownership of the yacht. Now, of course, this indirectly leads to another problem. What buyer in his right senses is going to buy a yacht known to belong to a distressed seller when a large chunk of that debt is going to follow the yacht? So it's a bit of a double-edged sword. You opt for a private sale because you know you can get the best price, but then on the other hand, what buyer is going to buy a yacht knowing that that yacht is loaded with debt? So that's not going to get you very far. Which means that the best option really and truly is the judicial sale. And why is the judicial sale the best option? The judicial sale is the best option because, number one, it's sold under the authority of a court. Number two, the vessel is sold free and unencumbered. Now, what does that mean? That means the opposite of what I've just described. That means that the yacht is sold without any debt. The debt, which would have belonged to the previous owner, no longer attaches to the vessel. It is sold free and unencumbered, and the debt then attaches to the proceeds of the sale. Why? Because in a judicial sale by auction, the court orders the sale, the proceeds, the sale price, is actually deposited in court, and all the debtors then argue over the proceeds. So far so good. Now, we normally, most jurisdictions have two forms of judicial sales. They have the traditional judicial sale by auction, and we also have what is called the court-approved private sale. Both of them are judicial sales, and both of them come with the bonus that on the sale, the vessel is sold on free and unencumbered. So if you go for the judicial sale, either one of those two, how do you get there? What is the typical scenario? And I'd like to talk now and take a typical scenario of a mortgagee. The mortgagee, the financier, the bank hasn't gotten paid. The bank wants to cut its losses, so it needs to get as much of its outstanding debt paid as possible. So based on what I've just said, it needs to find a reliable jurisdiction. And of course, we like to think that Malta is a hugely reliable jurisdiction for all the reasons I will be explaining to you in a moment. Now, why is Malta a reliable jurisdiction? Well, it's the largest flag in Europe and sixth largest worldwide, which means what? Which means that a number of those lovely yachts are flying the Malta flag. So it makes sense for Maltese law to be regulating this whole matter. Malta is also bang in the middle of the Mediterranean. So very frequently, it is an ideal geographical location in terms of the bank taking possession of the yacht and being able to bring it to Malta. But most importantly, Maltese law gives creditors, especially mortgagees, a huge degree of comfort. And we'll be saying why in a moment. And in fact, it's a bit of a chicken and egg situation we're talking about here. It is that degree of comfort which Maltese law gives mortgagees, which has made our flag so popular. So the flag is popular with owners because owners do get a number of benefits. But one of the greatest benefits is actually given to the mortgagee, which we will see in a moment are the following. Under Maltese law, a Maltese registered mortgage or a foreign mortgage, if it satisfies the criteria established under Maltese law, is what we call an executive title. Now, what on earth you will be asking is an executive title? What does that mean? An executive title means that the mortgage is equivalent to a judgment. It is equivalent equivalent to a judgment and capable of immediate enforcement. Now, why is that particularly useful? That is particularly useful because that means that the mortgagee doesn't have to commence an action on the merits, doesn't have to prove his claim. The mortgage itself is equivalent to a judgment, so we can go straight to enforcement. Straight to enforcement. And what does that mean in the context of a yacht? It means that with a mortgage in hand, with that executive title in hand, we can go directly to arrest the ship. It means we can go directly to request the court to set a date for the judicial sale by auction, or we can ask the court to approve the private sale. Now, actually obtaining an executive title is quite simple. I don't want to bog you down with the details here because I'm also aware of the fact that time is pressing. What we need to do is the mortgagee needs to send a letter of default to the owner. That letter is, the judicial letter is then sent through the court system requesting the owners to pay, and it's served on the owner or the master or the agent or a person appointed by the court to appear for the owners of the vessel. Once that letter requesting the owner to pay up is served, and once there is the passage of 48 hours, that is what triggers the enforcement capability of the mortgage. So judicial letter, 48 hours, no payment, and that's when we can proceed directly with the judicial sale by auction or the court-approved private sale. So let's take these in turn now. Why should you opt for one rather than the other? Well, with a judicial sale by auction, the court, as you can see there on the screen, the court appoints the date. The court appoints a lawyer so that the lawyer can actually sign off the bill of sale once the transaction is finalized. The auction is held in the law courts building, and it's really like any other auction where a bidder would go there. There would be the auctioneer. Prior to the sale, the bidders are expected to deliver to the auctioneer evidence of their financial ability to pay up to a maximum price. And the vessels are sold to the highest bidder. There is no reserved price or minimum price. And I'd just like to open up a bubble at this juncture and say that this is perhaps one of the disadvantages of a judicial sale by auction, because since there is no reserved price, then, you know, there is a tendency for vessels to be sold at an undervalue because there is no reserved price. And I'd like you to bear that in mind because this is the main distinctive disadvantage compared to the advantage of the court-approved private sale. The successful bidder is then expected to pay the purchase price within 7 days. And on the date of payment, there is the physical payment into court. Now, how it all pans out is that we, as the lawyers for the execution creditor, will go there to make sure that everything is happening as it should. If we are acting for the buyer, then you will literally go to court, you will pay in the money into court, you will meet up with the lawyer who would have been appointed by the judge to sign off the bill of sale, and the bill of sale is signed off, as I said, by the lawyer appointed by the court, and the bill of sale will state very clearly that the vessel is being sold free from encumbrances and all the debts of the vessel from that moment on attached to the purchase price of the vessel. Now, that is what happens in a judicial sale by auction. So what happens in a court-approved private sale? I would like at this juncture to just remind you about the disadvantage of the pure private sale, which I spoke about earlier. You may remember that when I started off and said an owner can decide to sell his vessel, I also said which buyer in his right senses is going to buy privately when they know that they're going to be lumped with the debt. So that's a problem. But the advantage of the private sale was that you can get the price, you know exactly how much you're going to be selling your vessel for. The disadvantage with the judicial sale is you don't know till the last minute how much the highest bidder is going to bid for it. But the advantage is that it's going to be sold free and unencumbered. So what we as practitioners did in Malta was say, look, we need to find a happy medium here. We need to find a method whereby we can negotiate a price so we know exactly how much the vessel is going to be sold for without the uncertainty of the judicial sale by auction. On the other hand, we want it to be sold free and unencumbered. So in 2006, we came up with a number of amendments to our Code of Organisation and Civil Procedure, and we came out with a court-approved private sale. And the law states that the court may, on the application of any creditor with an executive title, i.e. the mortgagee, approve a private sale of a ship or a vessel or aircraft, because this applies also to aircraft, in favour of an identified buyer and in consideration of a determined price. It says also, the applicant shall, you can read it up with me, the applicant shall, together with the application, submit appraisements by two independent and reputable valuers, confirming the value of the ship or vessel or aircraft. It shall also be incumbent on the applicant to adduce to the court evidence that such a private sale is in the interest of all known creditors and that the price offered by the proposed buyer is reasonable in the circumstances of the case. That's a picture not of a yacht, but it's a picture of a cargo ship called the Thor Spirit. That was the very first ship which we sold. Fenech was responsible for the sale of the Thor Spirit, where we were acting for Danske Bank, and we have never looked back since. I can tell you that today the court-approved private sale is the preferred method of enforcement of mortgages by banks when there are defaults by the owners. And as you can see there, I've given you some samples of a number of sales which have been conducted. As you can see, the execution creditors are very, very well-known, very well-known financial institutions who have used this Maltese court-approved private sale very, very satisfactory, and they're very happy with it. So what the procedure would be, very simply, would be we would move to proceed with the arrest of the vessel, of the yacht. We would serve the notice of default. We would proceed with the judicial letter and allow the 48 hours to pass. That means that the title becomes immediately enforceable. Then the bank would send out letters to brokers, and I know there are a number of brokers present watching this and participating at this seminar today, notifying the brokers that there's a vessel for sale, there's a yacht for sale. In the meantime, when the brokers produce all the various, yacht brokers produce all the various interested parties, you would then come down to the best price and negotiate an MOA with the interested party, and an MOA is actually signed off for the purchase of the yacht, subject to court approval. In the meantime, we would also work on obtaining the two valuations required by the court to show that the price on the MOA is higher than the highest valuation. And that is when we file everything in court. We file the application, we file the notice of default, we attach the mortgage documents, we file the MOA, we file evidence that we've sourced the market, we file the two valuations. And basically the judge will order a hearing. And if he will order, he will normally order a hearing date within 3 weeks. So the process is also rather expeditious. It flows, it's very smooth, and there isn't much waste of time at all. Now, at that hearing, if the judge is satisfied that the sale is in the best interest of the creditor and there is no objection to the sale, then the judge will approve the sale at the price stated in the MOA. That is what normally happens. Infrequently, and to be perfectly honest with you, we've done several of these sales. Very frequently, the owner and the execution creditor are on board. The owner normally reaches a stage where he needs to make sure that he pays off his debt. He needs to make sure that, if possible, he's left over with some money left over. So very frequently, the norm is that the owner, the defaulting owner, and the execution creditor are actually working together. Every now and then, you get the rogue owner, and the rogue owner, we once had a notorious rogue owner called Nobu Su, and I feel very free to speak about this because it's all public domain. Nobu Su was a Korean gentleman who, just prior to the 2008 recession, convinced every single conceivable bank that it was the right thing for them to lend him several hundreds of millions, and he went on a major spending spree and bought hundreds of car carriers, and of course went belly up, and he tried to stop every single judicial sale taking place of any of his ships all over the world. However, and I mention it as an example because it made the headlines, but that is really, really a very rare occurrence. Normally, everything takes place according to plan. I've just got a rather interesting picture of the ships that we're talking about belonging to Nobusu. However, Nobusu, started to stamp his feet all over the world, but it didn't work. It didn't work in America. It didn't work in many courts in Europe. It didn't work in Malta, because his ships were still sold off. Fast forwarding to the closing, after all of this is approved, once the court approves the sale, a bill of sale is drawn up by the court-appointed curator, who will sign off the sale in favor of the buyer as per the MOA. Actually, I've got a mistake on that slide. It's not a court-appointed curator, it's by the lawyer appointed by the court to actually draw up the sign off the bill of sale. The purchase price is paid into the court, and the vessel again is paid free and unencumbered. And then there would be, after the vessel is sold off to the buyer, after the yacht is sold off to the buyer free and unencumbered, so the buyer goes off on his merry way, and that will leave the creditor, the bank, the execution creditor, with having to try to recoup the money which is owed to him. And that is when the purchase price is actually deposited in court, and the bank and all the other creditors will then commence proceedings related to the withdrawal of what is owed to them by and out of the purchase price. And I will conclude this presentation by giving you a very practical example of what happened on a yacht. And this yacht related to the Indian Empress. Most of you, of course, have heard about this very famous yacht. The Indian Empress was in Malta in 2018 when she was eventually sold off. Now, briefly, the facts of this case was this was a 95-meter yacht built in 2000, substantially refitted in 2015, originally built by the Qatari royal family. And in 2018, she flew the Isle of Man flag. In fact, she was owned by Indian Empress Limited, allegedly owned by Vijay Mallya. Most of you know was one of the wealthiest people in the world. In 2017, this owner had gotten himself into quite a lot of bother, resulting in him being unable to pay his debts. And in fact, the first time I arrested this yacht was in 2017. But at the time, I remember I had gotten frightfully offended, and he immediately paid off the debt. By 2018, however, I think everything got a little bit too much for him and was unable to continue to pay his debts. So the first creditor that arrested this yacht in Malta in 2018 was Melita Power Diesel, and they obtained a judgment for 651,000. And again, the Maltese judicial system, particularly when it comes to anything related to the judicial sale of ships, court-approved private sales, is known for its efficiency. Melita Power Diesel obtained their judgment in April, and the judge, very efficient, ordered that the yacht be sold in a judicial sale on the 21st of May. Now, there was an agreement between the creditors that was not going to give enough time for the advertising. So the creditors succeeded in filing an application and asked the judge to give them a little bit more time in order to take care of the advertising. And the judge agreed to postpone the sale to the 28th of June. Now, between the appointment of the new date of auction and between the appointment of the date and the actual date of the auction, there were a number of, this was a case which was full of court action. Barclays Bank, which had a substantial amount owing to it, had filed an application also to ensure that very important pieces of art were left on board the vessel. Barclays had a mortgage of 25 million euros, so it was in Barclays' best interest to ensure that the yacht fetched the best possible price. There were ideas of having pianos on board this yacht, which had belonged or actually played by Elton John, very important pieces of art. So Barclays wanted to make sure that everything remained on board in order to be as attractive as possible to potential buyers. The date of sale was on the 28th of June, The sale date happens, everybody goes to court, and the yacht is sold to an outfit called Yacht. Don't forget, this is a judicial sale by auction. Yacht for the value of 43,500,000. Now, as I said before, when you buy a yacht in a judicial sale, the buyer has got 7 days within which to pay the amounts into court. So this meant that the purchase price had to be paid in by the 4th of July. 28 June was the auction, payment price was by the 4th of July. However, when the 4th of July happened and came along, Yacht had still not paid in the 43 million. I have my own personal ideas as to why that was. Clearly, Yacht, I think, was very probably well, not quite a fictitious entity, but it was actually existed. But they had never intended to produce 43 million in any event. So Yacht filed an application the day after saying, can we please have another 7 days within which to pay the purchase price? And of course, the judge threw out that application because it became very evident that Yacht never had the intention of paying the money in the first place. So what happens there? We have a judicial sale by auction. There is the auction date. A yacht is sold off for 43 million, but the buyer fails to come up with the monies. Well, not a very happy Barclays Bank, I can tell you. So on the 13th of July, Barclays filed another application requesting the court to appoint another date for the sale of the vessel at Yacht's expense. It wants an order from the court to say that the bidders have to present a guarantee of not less than 35 million euros. It wants the court to prohibit Yacht from participating, and it also wants the court to order Yacht to pay the difference between the 43,500,000 it ought to have paid and any lesser price should the yacht be sold for a lesser price. Now, this put the judge on the spot in Malta, and I'll tell you why. Because, as I said, in Malta, you cannot have a reserved price. So the judge could not agree to a guarantee being put up by bidders for 35 million. So the court couldn't go down that route. But what the court did was the following, as you can see there. It set a new auction date for the 19th of September. Yacht was outrightly prohibited from taking part in the auction and ordered that Yacht would have to make good for the difference in the purchase price if that purchase price was less than 43.5. So there we are, set for another auction to take place on the 19th of September. But what happens? What happens is that just before the auction, Barclays Bank filed an application to ask the court to approve a private sale. So obviously what must have happened was that Barclays Bank decided to source the market. They found a private buyer, and it wanted the court to approve that private sale. So here we see one case where you, on the one hand, have a judicial sale by auction, which is then later on superseded by a court-approved private sale. And in fact, the court did fix a hearing date. There was no opposition whatsoever, and the vessel was approved for a private sale at 35 million. Now, very probably, the reason why there was no opposition is because when you count all the creditors of the yacht, they would have been paid off by the 35 million. So this was a really interesting combination of a case where you have two processes which sort of merged into each other. Now, the peculiarity here was that the buyer insisted that he did not want to have anything to do with the art. So this was the very first time I've ever dealt with a case where the buyer wasn't trying to get, his value for money. In this case, the buyer did not want any of the art, did not want any piano played by Elton John, so we had to go through the rigmarole of getting everything removed from the art before he actually took it off. And the bill of sale was signed off and the purchase price was paid into court. The buyer took delivery of the vessel free and unencumbered. And this is what happened to the execution creditor, of course, and I will very shortly be concluding here. Whether or not the funds were available for withdrawal depends on whether there are any other creditors, as I explained before. If there are no other creditors, then the execution creditor will take all the money. or what is owed to him rather, with the balance being paid off to the owner. If there are number of creditors and if the purchase price is not sufficient to pay all the creditors, which is not what happened in the Indian Empress, because in the Indian Empress, all the debt was, all the purchase price was sufficient to pay all the creditors. If that is not the case, then we have to look at a particular section of our law called Section 50 of the Merchant Shipping Act, and that will give you the ranking and the order in which creditors will rank. Now, as we speak, there are several other yachts under arrest in Malta. However, unlike merchant shipping, yacht owners who are unable to pay their debts feel very, very uncomfortable, and there is a higher degree of confidentiality, although an arrest is total public domain. But what I can tell you is that as we speak, there are a number of rather important vessels, yachts owned by important people, who are under arrest. However, all of these hope to be able to reach an out-of-court settlement precisely to avoid all of what I have described to you, which is what happens after you arrest a vessel. Just by way of general conclusion, these are 3 vessels which we only sold last month. We had the judicial sale of 3 merchant vessels, the Algarrobo, the Andes, and the Andino. And again, to conclude, we are currently working on a very important draft convention at UNCITRAL, which is the United Nations Commission for International Trade Law. I am the representative of the Comité Maritime International, which is the organization which drafts international convention, and we are at the moment discussing in draft form an international convention which is geared towards ensuring that there is the international recognition of judicial sales, meaning that there will be international recognition of the free and unencumbered title passing on to a buyer when a vessel is sold in a judicial sale by auction. So that is it. Thank you very much indeed. Thank you, Quaynote. I hope it's given you a little bit of food for thought. And of course, if you have any questions, those are our details. Please feel free to get in touch with us. Thank you, and I hope you have a great day. Thank you very much indeed.